Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 57 of the Case a Day series journey covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Please be aware that the case recordings are available on TikTok, YouTube, Instagram, Facebook, Twitter and on Spotify too. Simply search Law with Dunk the Law Guy or at Dunk the Law Guy. And to law teachers and students who may prefer an electronic copy instead to read from, so far I've uploaded both PDF and Word document versions of actus reus, causation and mens rea handouts to my shop on test.com, which I hope will help you should you want these. The shop is called the Law Guy _Law Library Shop. Once launched, I'll be uploading these to my website too, which will be called thelawguy.co.uk. Today, I'd like to cover another assault case of RV Dume, 1986. In this case, a police officer was wounded after being bitten by the defendant's dog. The attack was initiated after the defendant had instructed his dog to kill the police officer. The dog subsequently went on to knock the police officer over and then bite his leg. The defendant tried to argue at trial that his dog was full of energy and that the dog was simply exhibiting his natural behaviour around people rather than acting in response to the defendant's instruction. Clearly, a number of offences could be associated with the dog biting the police officer, such as possibly a Section 20 offence under the Offences Against the Person Act 1861 due to the police officer suffering a malicious wounding, maybe via an omission, i.e. creating a dangerous situation. Please correct me if I'm wrong here. However, the court also held that it was an assault, apparently an indirect assault, which I've never heard of before, for the defendant to threaten the police officer when instructing his dog to kill him. Here, the defendant's threat or instruction to the dog to kill the police officer is clearly an act which caused the victim to apprehend immediate unlawful violence, and so the actus reus of an assault could be proven here. And the defendant could have either a direct intent or most likely be subjectively reckless in causing the victim to apprehend immediate unlawful violence. Please do correct me in the comments section if I got anything wrong there. And that's it for today. Thank you from Law with Dunk, the Law Guy.